With that, I will hand it off to Derek and Faye.
All right, I can start things off. Hello, welcome everyone. And before I introduce myself, I want to take a moment to welcome you. So, welcome. We have speakers and guests from not just across the country today, but also internationally, which is very exciting. So, welcome to you, and thank you for being here today. I know it's very late for some of you right now, so I appreciate you accommodating this. So, I'm Faye Vasilopoulos. I'm serving as editor-in-chief for the UIC Law Review this year. And we're especially excited for this year's symposium because the topic is incredibly meaningful and impactful, not just for one field, but for the entirety of the justice system. And while we all have different goals in our respective legal fields and different visions, as lawyers, we do all have the shared vision of continually just improving the justice system, both for victims and for defendants. So today, by coming together and all sharing our ideas on how to bring a therapeutic aspect into the US justice system, I'm hoping that our teamwork will, come together and bring us one step closer to that shared vision. So lastly, before I turn it over to Derek, I want to thank the board for so diligently editing everything and our authors for being so wonderful to work with. And to Derek Ray and to David Gergis for helping so much with planning, the logistics of the symposium. Well, I shouldn't say helping, they're the ones who planned it. So thank you. And Dean Amy Campbell, who is an associate dean at our school, and she is also a founding member and a current board chair at the ISTJ. So welcome and thank you for all your help. And I'll cut it short. So with that, I'll turn it over to Derek, our managing editor.
Great. Thank you, Faye. And indeed, welcome everybody to our symposium this year. Again, I recognize that some folks are going into the wee hours of the morning tonight. So I definitely appreciate everyone joining and taking the time, like Faye said, to participate in the symposium. Keep the remarks brief. This symposium has been approximately a year in the making. As managing editor, one of my responsibilities is to organize the symposium from start to finish. Unfortunately, my predecessor had connected me with Dean Campbell to kind of get the ball rolling, and all of her help has really made a difference in making this symposium last and bring it to where we're at today. So thank you, Dean Campbell. Um, this symposium has been going on, like I said, for about a year. We had the call for submissions in May. In August, we selected which authors were going to speak, or which authors were going to write and speak for us. From August until approximately January of this year, our authors wrote their articles. For the last few months, we were editing and publishing those. It's been a really, really fast timeline, and a lot of people put in a lot of work to make this happen. I want to give special recognition to our editorial board, Fatima Sadiqua and her team on the lead article side, Jordan Robinson, who is also one of our authors this issue on the student publication side, and her team. David Gergis, again, has helped with the technical aspects of this symposium. Um, Faye, our editor-in-chief, has been certainly my rock throughout our time on the editorial board. And so many other people have helped make this year in law review and help make this symposium possible. Our faculty advisors, Frank Young, our reference librarian, and of course, as I mentioned, Dean Campbell, helping put all of this together and help solicit all of our authors and kind of being there every step of the way. So first, you'll hear from Dean Campbell, and then you will hear from our various lead authors. We'll have a brief 10-minute intermission, and then our student authors will speak in the second half. So with that, I'll go ahead and let Dean Amy Campbell take it away.
Thank you so much. Just lovely to see the names and the faces here today. I thought it would be, I would, for a change, not wing it and actually write some remarks. So excuse me while I put on my readers with my aging eyes. It's really depressing. But first, my deepest thanks to Derek, David, and Faye, and the entire UIC Law Review team for the honor of being asked to help open today's symposium. for the invitation to provide a forward to the issue, and for their hard work and professionalism in putting together today's event and the series of papers and a topic near and dear to my heart, and that of our lead authors and others, right? Therapeutic jurisprudence. As Derek just mentioned, it's hard to believe that it was a little over a year ago that we first started talking about this at the urging of, as Derek had mentioned, the International Society for Therapeutic Jurisprudence board, and my colleagues, a few of whom you will hear from shortly, dear friends and colleagues, our immediate past board chairs, David Yamada and Shelley Kierstead. Among the many reasons I was drawn to the field of TJ were colleagues like these and our international reach, evidenced by our additional authors today who have also become treasured colleagues. At this time, when global connections might seem in doubt, let today be a testament to the importance of conversation and reflection with partners near and far, and belief in the power of learning and the importance of humility as we navigate law's role in shaping societal well-being. And when we see so much uncertainty, fear, and yes, anger across borders, let those of us joining today reflect what could and what should be as expressed by TJ. How can we respect human dignity, including through law? How can we restore and maintain mutually beneficial relationships, including through law and legal processes? And how can we continue to question the what is and study the what could be that draws upon the best of law to advance human dignity and dignity-enhancing relationships? So I really look forward to today's discussion and conversation of just these ideas, starting with our lead authors, followed by our student authors who truly bring me great hope for better tomorrows. So again, thank you for joining us today. Let us begin. And Derek, I'll turn it back to you now. Thank you.
All right. Thank you, Dean Campbell. So our first author is Professor David Yamada, and I'll let Professor Yamada take it away in just a second. For everyone else, you're more than welcome to go cameras on, off, however you want. I would just ask that our authors go cameras on when they're speaking. Otherwise, I don't think I could do justice to introduce everyone, and for the sake of keeping everything moving along, Professor Mata, the floor is yours.
Okay, thank you so much. Happy to be dialing in or calling in from Boston today, and delighted to join you folks. I do want to thank Dean Amy Campbell, one of my longtime friends and colleagues, for getting this symposium going and approaching the law review about it. I also want to really thank the editors of the law review, especially the Volume 58 editors. I had experienced an unexpected death in my family last fall that really delayed my completion of my article. And I have to say that the professionalism and the kind understanding that the board members showed in working with me to accommodate my schedule um, was just so deeply appreciated. Also, because I know that when an author is getting something in late, it creates a chain reaction where all the editors have to adjust their schedules in time. And you did so just so graciously. And I just wanted to let you know that your courtesy enabled me to complete an article that I've been contemplating for some time, uh, looking at questions of how what we're learning about psychological trauma can inform the making of law. And so the purpose of my paper was really to try and set out a framework for looking at when should understandings of trauma inform the creation of legislation, and if so, how, and then to provide an example of that in an applied way by my own drafting of legislation over the years concerning a form of workplace mistreatment that we call workplace bullying. So, what I'm going to try and do during my few minutes here is to first talk about uh, traumatization and what does it mean to be a trauma-informed lawyer and what does it mean to be practicing trauma-informed law, and then really how does it relate to the design of legislation. And then really, I'll be limiting more towards the end how I applied it in my article concerning my own public policy and legislative drafting and advocacy work as an academic and as a lawyer. So first, what does it mean to be trauma informed, relevant to the law and to being lawyers? Um, I think it helps to first understand the science, right? Um, we're talking about traumatic events leading to traumatization. And by traumatic events, I'm talking about things like experience in combat, a natural disaster, really severe forms of interpersonal abuse, horrific mass experiences such as genocide and mass shootings. Um, and those situations, in terms of how they affect individuals, often lead to traumatization. And the most common diagnosis we tend to associate with traumatization is post-traumatic stress disorder, as well as other sort of manifestations of stress and anxiety. And for those of you who haven't really thought about what a definition of PTSD is like, I'd just like to briefly, believe me, I'm not going to read a 58-page paper at you because you'd be just signing off after about 3 minutes if I were you. But this is a general definition of trauma or traumatization in PTSD. PTSD can result from a variety of traumatic incidents, such as mugging, rape, torture, being kidnapped or held captive, child abuse, car accidents, train wrecks, plane crashes, bombings, or natural disasters, such as floods or earthquakes. Its symptoms may include flashbacks, nightmares, severe anxiety, and uncontrollable thoughts about the event, even when there is no longer any danger. The individual of PTSD may be the person harmed. That's the usual way we might think of it. But it also can be the loved one of someone who was harmed or a witness to that traumatic event. So that's just a basic stock definition of PTSD that sort of captures a lot of different definitions. But I think what I want to make clear is that we're not talking about unpleasant or upsetting experiences, sort of the ordinary stressors of life. Yeah, before we started, I was joking about my responses to faculty meetings, and even though I might say that they were really traumatizing, no, it's not about PTSD. It's just that, I mean, it's about faculty meetings. So I think you get what I'm talking about here. It's the bad stuff. And as a result, severe mental and physical health consequences are manifesting. So that's what we mean when we talk about genuine trauma, and when we use the term trauma-informed law or trauma-informed lawyering, it really does relate to that more sort of clinically diagnosable condition where somebody really is suffering from an incident that would be just, terribly difficult for any of us to deal with. And so when we talk about trauma-informed law, most of the time it's talking about what lawyers do, how they understand their work relative to trauma. So let's think about fields of practice such as criminal law, family law, immigration law, military law, certainly with veterans' rights, human rights. Um, those are the types of practice fields where you tend to see a lot of traumatization because of the experiences of people that end up becoming legal events. And that experience of being traumatized may affect someone's ability to tell a coherent narrative. The brain science about traumatization teaches us that it really mixes up our heads in terms of being able to sort out and share information logically. It may also undermine our memory on important legally relevant events. And for lawyers who need legally relevant events shared in narrative ways, that can be very difficult when you're dealing with a traumatized client. So that kind of focus on trauma and traumatization is where a lot of the work has been done about trauma-informed law. Now, I'm suggesting we also have to shift the focus more or share the focus more with how should our understanding about traumatization shape the way the law is actually written and designed. And that's sort of the big picture frame that I've attempted to set out in this piece. And I'm not going to give it all to you in this brief time we have together, but I just want to share a couple of relevant points. Um, First, it's really important to go to the people who are the experts. If you want to learn about psychological trauma, uh, you don't want to rely just on lawyers interpreting what others are saying about psychological trauma. It helps to go to the experts themselves. And that's what I did in my article. And one expert that I'd like to invoke here is Dr. Judith Herman, one of the pioneering experts in traumatization, both in terms of understanding and practice. And years ago, she wrote a really foundational book about understanding trauma and recovering from it. And then very recently, a few years ago, she wrote another book talking about how we should look at trauma not only as an individual injury, but as something that has very public ramifications. And so she now is writing about trauma and justice, and it's in the form of this book, Truth and Repair. So hold on a minute. I just dropped my notes to the floor. I don't have much space here, but all right, there we go. What I'd like to just share with you are a few bullet points about what Dr. Herman found when she was interviewing victims of traumatization, oftentimes domestic violence, sexual assault, situations like that, abuse like that. And she literally was asking them, "What do you think of justice? What do you think are the things that we should be looking at when we imagine the system responding to justice?" And again, apologies for flipping pages around, but these are the main points that she got from her interviewees. First, they want acknowledgement, just an acknowledgement that a wrong was done and that it have some public significance. Second, an apology, that a perpetrator, an offender, provide a genuine apology for the traumatizing offense. Uh, Thirdly, accountability. In other words, sort of a systemic accountability that really does honor some sense of justice. A fourth factor that she found is that people, and this is makes sense, restitution. In other words, sort of a tort type of thinking about making someone whole, even though I think that phrase might be a little hard to reach when it comes to traumatization, but at least restitution that allows somebody who's been traumatized to make those steps forward in their life with the kind of resources that they need to get to that point. Fifthly, rehabilitation. We're not talking about the trauma victim here, but rehabilitation in appropriate cases for the offender. It's not always possible in some of these cases. If somebody is sociopathic or psychopathic, it may not be possible to solve or cure conditions like that. But when possible, her survey cohort said, "We'd like to see these folks rehabilitated so they won't hurt others in the future." And finally, and I think this is a biggie, prevention. If we prevent this stuff from happening, it's a win-win-win across society, right? People aren't traumatized. We don't have to involve the justice system. It's a healthier society overall. And so those are the 6 points that I used in my piece to suggest that yes, there is a public policy reason or a public policy justification for responding to traumatization through legislation, through new laws. And if we look at where some of these laws might already appear, I think some of the examples become fairly obvious. For example, victim witness advocacy programs in our court systems, domestic violence laws, child protection laws. Obviously, on the criminal side, sexual assault laws. So those are just sort of four obvious examples of how traumatization is at least the harm of traumatization is reflected in the fact that we do have laws on the books. Now, the fact that some event might be traumatizing isn't necessarily the only factor we should consider. because as we know, when we're legislating, decisions on whether to legislate have to take into account all sorts of different factors, right? All sorts of different stakeholders, all sorts of different priorities. And I'm just going to raise a couple of them for you here. One is that we need to consider, or should consider, the role of litigation in dealing with or responding to traumatization. Why? Because the litigation process can re-traumatize people. Think about criminal cases or even like a personal injury case where somebody who has suffered traumatization has to tell their story over and over again, and that creates a re-traumatization dynamic. And so, at least in my opinion, designing responses to traumatization should not be overly litigious in terms of just loading up our system with multiple forms of resolving conflicts that trigger that kind of re-traumatization. The other thing we have to consider, and this is sort of the hard side of things, is what are the implications of regulation for economic and human activity? And I'll just give you an example. We know, and this may come as a surprise to a lot of people, that one of the most frequent forms of PTSD or frequent causes of PTSD are severe auto accidents. Even if somebody wasn't one of the injured parties, auto accidents are responsible for a lot of reported PTSD. So let's think about this legally. If we wanted to eliminate PTSD from driving, what would we do? Well, first, we would ban all driving in Boston, where I live, because the drivers just absolutely suck. But I'm actually being a little not too flip in saying that the extreme version of saying let's eliminate traumatization from driving would be to say, okay, we just stop, people don't drive anymore. Everything's public transportation. But we know, at least in the United States and in many other countries, that's not a realistic public policy option, right? So then we have to back up and say, what are some of the other things we could do? And just three examples could be slower driving limits, right? Lower driving limits. We know that the more you raise the driving limit, uh, the more accidents we're going to see. Um, More speed bumps. Now that could enrage certain drivers and cause a lot of busted up cars, but maybe more speed bumps on streets where people tend to race through. Another option, looking at the criminal side, is stronger DUI laws, because we know that some of the worst auto accidents have been caused by people under the influence of alcohol. I'm not saying that any of these responses are the answer. In fact, there's no such thing as the answer. But I'm suggesting that one of the things that we have to do is when we recognize activities that could be traumatizing, we also have to consider other priorities in weighing whether or not the law acts in a regulatory and intervening manner. So that's just part of the general frame that I set out in my paper. And in terms of its applied sense, I'll just sort of briefly mention some of the work I've been doing, the kind of work that got me interested in traumatization in the first place, because I am an employment law professor, and I have to say that when I started this work in terms of thinking of law reform, I thought of it mainly in the way of rights and responsibilities. But when I started to understand more deeply certain types of behavior, certain types of mistreatment at work, I started to look more deeply into these questions of the psychological experience of being in the workplace and the psychological experience of being severely mistreated. And so in the late 1990s, I heard this term being bandied about called workplace bullying, and I had not heard it before. It was a term that got its originated in England. They like to use that term bully a lot, so it made sense that they would use some manifestation of it to describe bullying behaviors at work. But in essence, what are we talking about? This is sort of a non-legal but a general definition. We're talking about repeated, often repeated, health harming mistreatment of a worker. using measures such as severe targeted verbal abuse, threatening, intimidating, and humiliating behaviors, behind the back sabotage of someone's reputation or work performance. Um, in other words, we're not talking about just ordinary dust-ups in the workplace, people having bad days, people, getting angry on occasion. We're talking about oftentimes these targeted campaigns of abuse that are designed to drive someone out of the workforce and oftentimes designed to drive somebody out of their livelihoods. And I'll just briefly read what a pioneering journalist in England wrote about her understanding of workplace bullying. She said, this is Andrea Adams, and she was the first person, a journalist back in the 80s, to use this term workplace bullying. And she said, workplace bullying constitutes offensive behavior through vindictive, cruel, malicious, or humiliating attempts to undermine an individual or groups of employees. This abuse of power or position can cause such chronic stress and anxiety that the employees gradually lose belief in themselves, suffering physical ill health and mental distress as a result. And that captures the heart of the kinds of behaviors that I've thought the legal system should be more attentive to, because we're talking about severe harm to livelihoods, careers, as well as to health and well-being, reduced productivity in organizations, higher turnover. Some things I mentioned are win-win. This is a lose-lose. The sad thing in the United States is that workplace bullying is largely legal. That puts us at odds with almost every other country in the so-called Western world. And for the last, well, since the early 2000s, I've been advocating for a bill that I wrote called the Healthy Workplace Bill to fill in that legal gap. The Healthy Workplace Bill is designed to create a legal right for somebody to sue in a court of law for severe targeted workplace bullying. It's got a fairly high threshold for recovery, but it's designed to fill in that gap. And so I and others have been advocating for this law reform for many years. We have not succeeded in getting it fully enacted in any state, although some states, including California and Utah and a few others, have adopted parts of this proposed statute. But in any event, I reached a point where I said, because of this stuff I'm learning about trauma, is this bill that I wrote as trauma informed as I'd like it to be? And when I looked at it, kind of in the mirror, I said, no, I think maybe it's time for a different approach. And so I wrote a new proposed statute called the Workplace Bullying Accountability Act, where the emphasis is not on creating a legal right to sue, but rather on prevention. And in essence, the new Workplace Bullying Accountability Act imposes a legal duty on employers to have policies and procedures for handling complaints about workplace bullying, for educating their workforce, and for investigating these complaints fairly and taking remedial action. In other words, it says, employers, this is your duty of care. The legal kind of hook there is that an employee can sue the employer if they fail to fulfill their duty of care, and that worker is harmed by bullying as a result. But the key switch here is that the emphasis is on prevention, response, education, and that the litigation part comes in at the end. Why? Well, here's more of the trauma-informed part, because I've learned over the many years of doing kind of stuff that I do, that employment litigation in the United States is a really miserable experience. Civil litigation in general is a miserable experience, except for the lawyers, maybe, if you really like, writing up motion papers. But the key there is that if we can dial down the amount of litigation while still promoting prevention and response, that's a better sort of engineering in a trauma-informed perspective. So that in a nutshell is what I put in, like, I don't know, 50 something pages. And it does include the text of this new Workplace Bullying Accountability Act. I'm happy to report that here in Massachusetts, it has been not enacted, but it has been introduced into the Massachusetts legislature. So it's got a real life start. You folks are the first audience to hear me talk about this in an academic sense like this. And also the article I wrote is the first to report on the bill being introduced. And so in many different ways, this has been a wonderful opportunity for me to collect so many of my ideas together, sort through them, and then relate it to work that I found very meaningful. So with that said, I'm going to turn it over to our next speaker, but with thanks again to the Law Review for giving me this opportunity to be part of this event and to write this article. Thanks so much, everyone.
Thank you, Professor Yamada, for kicking us off. Awesome first presentation. So for the sake of keeping everything moving, we're trying to keep everything within 20 minutes for each author. So if you finish a few minutes early, we have time for questions. We actually just hit 20 minutes on the dot. So with that, I'll pass it on to our next speaker. Tamar Ben-Dror is here to talk about her article. Unfortunately, her co-authors were unable to join us today, but her article on community courts. Tamar, take it away.
Okay, thank you very much. Do I have, can I share a presentation?
Yes, 1 second. Okay, go ahead and try now.
Okay, do you see my screen? Okay, perfect. I can't see all of you, so if there's anything, please, if you don't hear me or anything like that, let me know. So good afternoon to you. Here it's 10:38 p.m., so late. But I'm really, really happy to be here and thank you for having me. I'm a PhD student at Bar-Ilan University, and the paper I will present is part of a series of papers from my PhD on success and crime victims in community courts. And this research was also part of a 4-year evaluation research project of community courts in Israel. The research was led by Professor Tali Gal, Professor Hadar Datzig-Rosenberg, who is also my wonderful supervisor, and Professor Avital Mentovich. I'm excited and honored to be here and also represent on behalf of Professor Hadar Datzig-Rosenberg and Professor Tali Gal, co-authoring this article. Both of them had prior commitments, but are eager to view the recording and also asked me to send their very warm regards to their colleagues here. And I also want to thank the UIC Law Review team again for all their hard and thorough work you have put into this special issue and this wonderful symposium. And really, it was a pleasure working with each and every one of you. So I'll go forward and can you see I switch? Yeah, okay, perfect. So community courts offer an alternative to traditional criminal justice, focusing on rehabilitation. I'm excited to share some key findings from our research on what outcomes we can take into account when we try to understand the extent of program impact. By examining program outcomes and perspectives of both graduates and non-completers of Israeli community courts, this research explores a more comprehensive picture of program impact. So our main question was, what are the metrics for defining success in the community court program at the individual and the systemic level? We looked at this from completers and non-completers' points of view. Traditionally, success is measured by recidivism rate, treating program completion and dropout as a binary concept of success or failure. This approach seems to or could overlook meaningful progress participants make, like finding stable employment, rebuilding family relationships, or managing mental health challenges. And we analyzed the experiences of both those who completed the program and those who dropped out. By doing so, we proposed a broader framework for evaluation, one that captures both rehabilitative achievements and system-wide impact. Ultimately, our goal was to develop better metrics for understanding what truly works in community courts and how their success can be more accurately measured. So to understand this question, we have to take a look at key components of community courts like collaboration, enhanced information about participants, individualized justice, accountability, and community courts emerge from the disillusionment from adversarial criminal process. They operate at the trial court level, aiming to provide comprehensive solutions to problems faced by defendants, victims, and communities. Their core premise is that preventing recidivism requires addressing the root causes of criminal behavior, rather than responding with incarceration. To further understand our question, we also took a closer look at the theories that shaped the development of community courts. The establishment of community courts worldwide has been influenced by four distinct theoretical frameworks. These underpinnings have shaped both the development and operational characteristics. They also shape the goals of community courts. So, of course, the main objective is reducing recidivism, but we argue that evaluating community courts solely based on their efficiency overlooks their broader purpose. These courts embody key principles of therapeutic jurisprudence and community justice. By integrating therapeutic jurisprudence, community courts prioritize rehabilitation and individual well-being. Their community justice orientation, emphasizing collaboration with local resources, restorative practices, and long-term reintegration or integration into society. This theoretical foundation guiding our examination of community court success. We focused on how these courts align with their foundational principles, offering participants meaningful opportunities for long-term change and fostering broader community engagement. So we also took a look at the operation of community courts in Israel. In a nutshell, unlike community courts in other countries, the Israeli model stands out in its acceptance of cases involving more serious criminal offenses. Each court is set up after a detailed local needs assessment. The program itself is made up of 5 phases. Participants progress through the phases based on decisions made by the judge, who considers recommendations from probation service, and input from professionals involved. Traditionally, the success of community courts has been measured by their effectiveness in reducing recidivism rates among program graduates. While reducing recidivism is essential, relying exclusively on this measure may be insufficient. In Israel, the system mainly uses the binary success model, graduates and dropouts, completers and non-completers. So what we did was conducted semi-structured in-depth interviews with participants who completed the community court program and those who did not. The study followed an approach which presumes that knowledge of perceptions and attitudes resides with the participants themselves. This approach seeks to identify the common themes of a particular experience and develop an understanding of its essence. We found 7 themes described by the participants when looking at what enabled success and what got in the way of success. We looked at barriers and facilitators to success, personal gains and losses, and systemic dimensions that participants talked about. After looking at these themes, we explored the possible metrics. So, what are these themes? One theme was the common background. Interviews revealed several common backgrounds for both completers and non-completers, including unstable family dynamics, lack of supportive figures, the economic hardship. As one participant noted, they get out, have nowhere to go, and end up right back to stealing. It's all I knew. From this background, both groups talked about internal motivation. This was the second theme. Many completers mentioned internal motivation as crucial to their success. Even non-completers emphasized its importance, often stating they weren't ready to help themselves. A third theme was relationships with court professionals. What the participants talked about was feeling seen and heard. I was lucky to be heard by two judges who really understood my situation, as one non-completer said. They felt they were building trust. Participants developed trust in the system through positive interactions. And they talked about family-like support. Like one completer said, I don't even say I'm going to the court. I say I'm going to my family. This is something I never experienced with my own family. And some non-completers expressed disappointment with staff relationships. Fourth theme regarded relationships with family and community. Both completers and non-completers recognized the importance of improving family and social relationships. They emphasized the limited support they received before the program. Many participants described isolation. I've been alone for many years, alone without friends. They also talked about improvement weren't evident. Participants acknowledged that strengthening relationships is a gradual process that takes time. They also emphasized the importance of cutting negative ties and being part of a therapeutic community, like group therapy. Some accepted that relationships with children might not be immediately restored, but maintained hope for the future reconciliation. A fifth theme was functional life changes, and the sixth one was internal transformation. These two were connected. A significant finding emerged regarding participants who withdrew from the program, who did not complete it. Interviews revealed that amongst non-completers, all but one reported meaningful benefits despite not completing the program. Some even said that the program changed their lives with new awareness. Most interviewees, both completers and non-completers, valued the practical support they received, including medical care, debt settlement, and employment guidance. Both groups reported significant internal change. As one completer said, I gained the strength to believe in myself. And one non-completer explained, when I arrived there, I understood there was another way. Today I know that everything you do has consequences. The last theme regards the participants' perspective for improving the program. The program's impact highlights the need for specialized support. This includes understanding the unique challenges of participants, the need for greater flexibility and consideration. Participants from both groups felt the program did not sufficiently accommodate their individual needs and challenges. Non-completers and completers believe that a more understanding and tailored approach would have improved their rehabilitation. They also said they experienced overload and competing demands as a barrier to success. Many participants struggled with the overwhelming number of program requirements, which made it difficult to balance therapy, court sessions, and daily responsibilities such as work and self-care. The intensity of these demands often led to frustration, exhaustion, and in some cases, not completing the program. The sudden loss in support upon exit was mentioned as well by many participants. Both completers and dropouts felt that abandoned when the program support ended. This sudden withdrawal of resources and guidance left them struggling to sustain progress and stability. So looking at these themes, we concluded three measures of success in community court. One was improvement in social and family relationships. participants, regardless of program completion, reported family and social ties were essential for future reintegration. Ending negative influences and building new support networks were key indicators for internal change. A need for post-program support was emphasized. The second one was enhanced trust in law enforcement and institutions. So positive relationships with community court staff help participants build trust in authorities. Many experienced a shift from skepticism to internal motivation for change. Trust building emerged as a crucial individual success metric. The third one was health and socioeconomic stability. Support in employment, debt management, and mental health significantly impacted participants. Economic stability reduced reoffending risk and increased social contributions. Concerns included lack of post-program support and rigid program demands affecting employment. To understand the system-level success, we concluded that there are benefits to moving from the binary approach of completion and non-completion. There are limitations to traditional metrics. Recidivism-based evaluations fail to capture rehabilitation and reintegration progress over time. Holistic measures of success could include personal well-being and social engagement. Shifting to a spectrum-based approach could benefit our understanding of what success means based on the goals and theoretical foundations of community court. Current evaluation sees participants as either successful graduates or dropouts or non-completers. Findings suggest a continuum of success, recognizing partial achievements as well. A more inclusive framework could improve support, structures, and long-term outcomes. So a more holistic approach could recognize achievements of non-completers. Many non-completers still showed positive progress in key areas. Of course, we recognize the limitation of these conclusions. These findings are based on Israel's system, which may not fully apply elsewhere. The study focuses on participants' experiences, but would benefit from other perspectives. And this has actually been done in Professor Dante Grosenberg and Professor Gal's previous article, Many Shades of Success, focusing on professionals' points of view. The success metrics, we suggest the need further testing to be standardized, of course. So future studies could track participants over time, compare different programs worldwide, and develop better tools to measure progress. We also need to explore structured transitions to help people move forward, even if they don't complete the program. So participants really need to cross a major bridge, and we believe that looking at these indicators to completion or non-completion creates metrics that help us better understand individual success and program impact. I'm gonna stop the sharing.
Great. Thank you, Tamar. We still have a couple minutes left of your section if anyone has any questions for you.
I have a question I would like to ask. Can you describe what the requirements of the programs were for the participants? And sort of, it sounded like it was quite a commitment, and I would be interested in just hearing a little more about that.
Yeah, so thank you for the question. It's a huge commitment for them. It's part of the standard of the program, and it's very individualized. So if a person were to deal with debt or with addiction or with domestic violence, they would get different, they have different programs tailored for each individual. And the phases are established prior until the end of the program. And if they see that there are different needs that aren't met, they do bring in different help, but it is very intense. So it's an intensive program.
Thank you.
Thank you.
Thanks, Jordan, for your question. I think we have time for maybe one more if there are any other questions. Okay, seeing none, Tamar, thank you so much for teaching us a little bit about community courts and again for staying up so late. We definitely appreciate your time. Thank you for speaking.
Thank you. And thank you very much for accommodating and shifting all the hours. And thank you.
It's a team effort for sure. No worries. So yeah, our next speaker is Professor Shelley Kierstead. And so today she will be talking a little bit more about like trauma when it comes to like child protection cases. So Professor Kierstead, take it away.
Thank you so much. I'm just doing a little finagling here with my screens. So bear with me for just a moment. Hello, everybody. Lovely to see you. Okay, I think I am ready to roll. So coming to you from Toronto, where it's finally starting to feel just a little bit like spring. It's making, at least Mother Nature is starting to pretend that spring might be coming. So I'll take that. So yes, I am going to talk a little bit about trauma. And I want to do that in a way that, as I think you'll see as I roll along, combines a couple of interests that I have developed over the years through both my teaching and my research. So in the context of the work that I do as a legal writing teacher, I've thought a lot about...
Forgotten. There's a TJ
Oops.
on now.
Oh. I've thought a lot about the impact of words in relation to sort of how legal counsel interact with one another, how pleadings are drafted, and sort of how those words can have beneficial or kind of anti-therapeutic, to use our TJ lingo, impacts. And then in the context of my child protection law teaching and research, I've become increasingly aware of the growing research on trauma and trauma-informed practice. And so thinking about those two things, sort of the impact of words and the impact of trauma on individuals who are engaged in child protection matters, got me to this topic, which is, as you can see, trauma-informed judicial practice meets therapeutic jurisprudence. So what I want to think a little bit about is the promise of compassionate judgment writing for the dignity and hope of parents who are involved in child protection proceedings. And so I'll tell you just a little bit in the next couple of minutes about how the paper kind of unfolds. So we know that trauma impacts people in many different areas. And of course, David Yamada was talking about, employment law, key example. But what I've done is I've kind of narrowed my approach to child protection. I've done that because it seems to me that this is one of the areas where there is such a significant potential impact involved with, think about it, removal of a child from a family unit, which is what sometimes child protection proceedings lead to. And our Supreme Court of Canada has recognized the inherent dignity of individuals and significant impact that these decisions have on both children and parents. So I kind of thought I would share the thoughts that I have about judicial writing and the value of compassion through the lens of child protection matters, but I think it could be expanded quite readily to other areas as well. So there is a lot already written about the impact of trauma on children. And of course, the key part of child protection proceedings and the whole child protection regime is to try to avoid, stop, or at least minimize the trauma that children who are part of the child protection system may have experienced or may experience if they're not taken to, or if better circumstances are not created for them. But I think it's important to keep in mind that children's trauma is not the only trauma that we need to be aware of in these kinds of cases. What do I mean by that? Well, research suggests, and I talk about this in my paper, that a considerable proportion of the caregivers who we're dealing with, the parents who are part of this, these proceedings, have themselves experienced significant adversity. And I'm not, again, to kind of piggyback on what David was saying, I'm not just talking about they've had, a few bad days or, some negative experiences. We're talking about significant and often prolonged traumatic experiences. So, for example, a 2018 Ontario study identified intimate partner violence exposure as the most prevalent risk factor at 53% amongst primary caregivers in cases where child maltreatment was substantiated. This form of violence is widely recognized for its potential to inflict complex trauma. And it's been noted within research that complex trauma often leads to significant impairment in personal, family, social, educational, occupational, basically every area of functioning. And there's also a strong body of research that's established a correlation between what we call ACEs, adverse childhood experiences, and subsequent difficulties in childhood. Also, within the Canadian context, this paper pays attention to the gross overrepresentation of Indigenous children and families within the child welfare system, and the ensuing intergenerational trauma that some of the historic injustices have inflicted plays a role in bringing some families into the child welfare system. So often what we see is complex and intergenerational trauma being the areas of trauma that are noticed in are present in child protection cases, but it is not unheard of to encounter a simple or what we call an acute trauma arising out of a reaction to an individual event, as well as institutional trauma, which is sometimes related to intergenerational trauma. And I talk a little bit more about that in the paper, but cognizant of the fact that I am quite often a little bit of a violator of time limits, I'm going to try to move on and not be a violator of the time limits today. So I also want to say I'm aware, I'm talking about judgments and the words in judgments, but I'm very aware that written judgments are the end product of the associated proceedings. So in other words, judges are making decisions and writing judgments that flow from the evidence and the submissions that have been presented to them. And I really do believe that a trauma-informed legal practice assumption and application throughout a child protection case is critical. But again, that's a topic for another discussion. The other thing I wanted to say is I'm not in my paper arguing that trauma-informed, TJ-focused approaches necessarily should result in a change to the way the law is applied. I'm not going there. I think there is work to be done there, but I'm not going there. And I accept for the purposes of this work, the author Susan Bandez's argument that, and she says, compassion is not, at least on its own, a reliable predictor of who ought to prevail in a legal dispute. But I also adopt the position of SAMHSA, the U.S. Substance Abuse and Mental Health Services Administration, that says for a person who has experienced past trauma or may still be experiencing violence in their lives, a judge's words can be potentially hurtful or potentially healing. And I think that's really important for judges and for lawyers who are providing judges with the materials with which to write their judgments. I think that's really important to keep in mind. I also in the paper review work from others who've suggested that providing litigants with a sense of voice, of having been listened to, and motivating litigants to move toward more healthy futures can promote their dignity interests. I also suggest that providing judicial reasoning that acknowledges parents' strengths along with their weaknesses can help children better understand the reasons behind their placement in different households. So in other words, if the judgment reflects the complexity of the situation, the fact that, yes, there were weaknesses that have potentially precluded this parent or these parents from continuing to parent the child, an acknowledgement of their strengths and where the evidence demonstrates it, their love for the children, can be helpful for children who later on are reading those judgments. And it was interesting. I did a kind of an earlier version of this presentation when I was sort of drafting this paper with some judges. And they had some interesting, varied comments, but this one really seemed to resonate with them. The fact that what they were writing might actually later be something that the children would have access to and be impacted by. So what I am suggesting is an approach to written communication that, again, recognizes the profound impact of trauma on individuals' actions and reactions, and that responds accordingly. So, hopefully, judgments that acknowledge the presence of trauma, right? Respectfully recognizing and articulating, where appropriate, the presence of various forms of trauma and their potential influence on the parent's behavior. Recounting evidence with sensitivity, right? And again, summarizing evidence in a manner that acknowledges the potential impact of trauma on a parent's actions or inactions, while of course, not soft selling the impact of the behaviors on the legal considerations. And acknowledging a parent's strengths and positive attributes, and avoiding unnecessary blaming language that would add to the shame and that is often associated with trauma. Fostering a sense of hope and, where appropriate, articulating a vision for future healing. So what I do in the paper is I look at 3 different judgments, and in keeping with kind of wanting to take a positive approach, I changed paths to some extent. Initially, I was going to look at judgments that I thought represented not so positive examples of judicial writing. And instead I thought, why not take a positive approach and look for examples of writing that really do the things that I'm suggesting are helpful, are kind of TJ focused, if you will. And so I'm just going to kind of look at a couple of excerpts here, which I hope will demonstrate some of what I'm talking about. Here we have quite a complicated and difficult situation where the judge says, mother is Indigenous, her truth involves intergenerational trauma, which can have a huge impact on a person's life, including their parenting skills and addictions, right? So just an acknowledgement and an acceptance that mom has suffered intergenerational trauma that has impacted her life. And then the next quote was quite interesting. Here what we see is that the judge is saying, mom was late. Sometimes she, one day she kind of left in the middle of being re-examined. And again, I want to pull back into something that David said earlier. Litigation can re-traumatize, can be traumatizing for people. So, mom leaves in the middle of being re-examined. She disconnected. She didn't return after the break. And the judge says, it happened, but despite the delays, the court is sensitive to the trauma that mom had already suffered. The delays and the failure to return were not held against her. However, before anyone sort of worries that the judge is just not taking into account the difficulty, the judge definitely did take into account the difficulties, avoided inconsistencies in the mom's evidence, the challenges that she unfortunately did continue to face, which included excessive alcohol and drug consumption. But this is sort of a judicial response and acknowledgement to the realities that this individual was dealing with. And as I noted earlier, I think it's really important to the extent that decisions can to avoid re-traumatizing and to acknowledge those strengths and avoid gratuitous blaming. And here was, I thought, a really positive way that this same judge accomplished that mission. You can see that there are a lot of positive attributes here, right? She loves the children. When she is at Access, the visits have generally been positive. Now, there was a problem. She didn't always attend Access, but the judge says when she does, it generally works out well. And you can see the other positive attributes. Of course, this depends on the evidence that is before the court, but when it's there, why not highlight it? Again, it did not cause the court to shy away from the problems that actually led to the children being removed from mom's care. The court is concerned if the children were placed with the mother, her lifestyle would inevitably have a significant impact on the children. She's shown very little insight as to the protection concerns, has not demonstrated a prolonged period of sobriety or being free from domestic conflict. So, again, sometimes the difficult decisions are still the difficult decisions based on the law and the evidence. But attempting to just write the judgment in a way that is not only about the negatives, I think has that potential of respecting human dignity. And, here, this is just another example of kind of an encouraging for the future sort of finish to a judgment. And I'm kind of going down here into the middle of the slide. The mother has a lot of positive qualities as outlined in this decision. Encouraged to continue her treatment, participate in aftercare treatment, and then just the respectful. I sincerely wish her the best in her efforts to meet these challenges. Seems to me to be quite respectful and humanizing. So I wondered, because I've been talking a lot, and I wondered whether we could spend a couple of minutes and just see if we could look at, as a group, some possible rewording for some situations that a judge might be writing about. And I must give thanks to Magistrate Terence Brown, who we met in Barcelona last year, and who is very attentive to the TJ aspects of judging and of writing about judgments. So he gave me a couple of examples of ways that he kind of converts statements that on their in their initial form might just be quite negative to more nuanced recognitions. So do we have, Derek, do we have a couple of minutes to run through a couple of examples?
Yeah, we could take a couple minutes, maybe like another 3 or 4 minutes if that's all right.
Okay, so the respondent mother's relationships are categorized by domestic violence. Any ideas about rewriting that to be a little bit more compassionate, a little bit more reflective of what we might know about domestic violence and its impact on individuals? Any brave souls? Okay, I'll give you a hint on this one, and then I want to I'm gonna maybe do a teacher thing and call someone out for the next one. Maybe not though. Here's how. Oh, Clara, did you want to give it a whirl?
I'll give it a whirl. I
Good.
think something reflecting this idea that the mother has experienced domestic violence in her past relationships, something that reflects that this is it's not a choice, basically.
Yeah, great. I'll tell you what Magistrate Brown kind of reframed it as, and I think it kind of gets that part of what you said, Claire. So he said, first of all, let's name her. Let's give this person a name, not just the respondent. So Ms. Smith is a survivor of domestic violence. Her current partner is the perpetrator of that violence. And experiencing domestic violence makes it difficult to protect and care for the children. Right? So it's not really different information, except it's a different level of complexity being brought into that statement. And it's not just about, oh, she's this person who just, keeps getting into relationships that are whose signature is domestic violence. Okay, how about one more? The respondent mother has unregulated mental health.
Maybe we could try like Miss Smith struggles with different mental health conditions.
Yeah. And of course you'd know them, right? So yeah, exactly. Great start. So you might say, she's been diagnosed with depression or schizophrenia, and her symptoms, and then the unregulated, her symptoms return when she doesn't take her medication, right? So not just kind of labeling her as this person who just doesn't regulate her mental health, but kind of being more specific and more attentive to, this is about, these symptoms occur in certain situations. So anyhow, I think my own timer has gone off, so I'm going to suggest I'm out of time because I think I started my timer after I started talking. But I hope these are a few helpful things to think about. Again, to me, lawyers feed judges. So while this is written in relation to what I think judges should do, I think lawyers play a really key role in that process. So thank you.
Great. Thank you so much, Professor Kierstead. I mean, I really found this topic to be pretty insightful, and I personally had enjoyed when I was editing, reading some of the quotes from the varying opinions, and you can definitely see how impactful they are. So thank you for that. So our next speakers are Professor Carney Perlman and Itai Creighton to talk about TJ from the perspective of bankruptcy law. So go ahead and take it away.
Thank you very much, Derek. And hello, everyone. It's great to be here today. Dean Campbell, Derek, Faye, you did incredible work. We're glad to be here, as I said. And I think that our topic it's a very good example of how to expand the application of TJ into different branches of law and use the unique DNA of TJ to bring real influence on different laws. And I will share my screen. Great. Can you see my screen?
Yep.
Wonderful. So our article and research, a new chapter, TJ and the Path to Financial Rehabilitation in Bankruptcy Law. So just for intro, as you know, bankruptcy law is an essential field in the economic, social systems and legal systems of our modern society. And just as important component, consumer credit became integral to modern culture. And we bring different research in our article there are quite good research that existing. Just to give you about the scope, one of in 8 Americans have filed bankruptcy in their adult lives. And this is demonstrating the importance of bankruptcy law and the maximizing of the potential of financial rehabilitation. Now, financial rehabilitation is tied into social and economic values with impact on the debtor's surroundings, circles, including family, community, and society. And I think the journey of bankruptcy law along the years, along the history, is that it's not anymore a creditor's collection remedy, but bringing the importance of the rehabilitation of a debtor. And I think there is no better source than TJ, as we will demonstrate in the next slides. So accordingly, many countries adopted financial rehabilitation doctrine as a key objective, including enacting different laws into the DNA of the bankruptcy law in those countries, and with the understanding that we need to assist to achieve financial rehabilitation in terms of debtors. And it is a classic law in books versus law in action situation, that there is a gap between the legislative intent and the practical outcomes, as you will see, regarding financial rehabilitation in bankruptcy. And what we thought, Professor Perlman and myself, is what can we learn about rehabilitation from other fields of law. So we spoke about maybe the objective, how to address this gap, and our approach, as I touched in the beginning, is to examine bankruptcy law through the lens of TJ. And in order to do so, we are analyzing two legal systems in the United States and Israel, and the different challenges that they faced with financial rehabilitation. By the way, in many ways, we share a common challenges. When it comes to the gap between vision and reality, in the United States, we have the bankruptcy code, which is regulating the bankruptcy law in the United States and emphasizing the importance of rehabilitating and achieving a meaningful fresh start. Now, the term fresh start, as you know, is the common term, the terminology in the United States, which is in many ways the financial rehabilitation in United States, and we will see what is the practical meaning as of today and what we think should be done in order to improve it. In Israel, we have also in 2018 a very major reform with enacting the insolvency and financial rehabilitation law, and as you see, by the name itself and as a statutory goal, we have rehabilitation as an important key objective of the law. What both systems are lacking is a clear definition and implementation frameworks of financial rehabilitation. Now, when it comes to Fresh Start, one of the main problems that Fresh Start as of today is mainly rely on debt discharge, but that discharge alone itself is not a meaningful financial rehabilitation. And one of the ways that you can see that we can looking on debt discharge is the fact that there are empirical studies both in United States and in Israel demonstrating very clearly that there is a challenge with debt discharge, and as you see, debtors are finding themselves again in the cycle of debts or struggling to pay their bills, although they received debt discharge, meaning that there is a need to examine and to find the right mechanism how to provide them a real meaningful financial rehabilitation. Now, another important aspect is education related to debtors. And in 2005, in a reform in the United States, there been in the integration, which is very important by itself, of different education to the debtor, including pre-bankruptcy counseling and pre-discharge education. You can see, of course, the duration of those courses, and in Israel also. And one of the challenges or the limitation is the fact that those courses are brief, uniform. There are mainly generic information and education, which is not tailored or taking into account the specific circumstances or factors related to the debtor. And this is something that we wanted Kani and myself to touch in our research and to understand what should be done in order to improve those mechanisms. Now, when it comes to TJ, we would like to draw insights from the intersection of law and rehabilitation as explored by TJ movement and the application and what Thomas spoke before, the problem-solving courts or community courts in Israel, which are great place how to learn about rehabilitation. Now, just to highlight a few points regarding the problem-solving courts, which related to our topic, is the fact that, of course, problem-solving courts, most of them that we are dealing are criminal courts, are dealing with different criminal cases, but we can use those insights and to shift them with the proper changes into bankruptcy law. But when it comes to those problem-solving courts, we understand that their goal is to prevent the repeating of undesirable behavior, which is highly linked into bankruptcy, and the fact that we are speaking about an ongoing process. And think about, for example, the debtor education that I just presented in the previous slide. If we are speaking about a 60 minutes or 2 hours course, it's not an ongoing process. It's a one-shot intervention. Now, when it comes to TJ, we suggest to overlook on the structure on the way TJ is analyzing or touching different branches of the law and components in order to create this substantial improvement. And we are speaking about legal rules, legal procedures, and the roles of legal actors. And we are using this structure in our research in order to being able to analyze bankruptcy and how to import TJ and insight into bankruptcy law in order to improve and to achieve a meaningful financial rehabilitation. Now, when it comes to the judicial process as an opportunity for change, we need to look in terms of court on bankruptcy law behind debt collection and debt discharge and the underlying behaviors leading to bankruptcy. We do, of course, understand when it comes to legal arrangements the importance of debt discharge, but not by itself only. It should be one important component, ingredient that it's part of bankruptcy law and rehabilitation to provide a real fresh start, but it cannot be by itself. We need also a proper education and practical tools for financial management. Another aspect is the holistic and individualized view of the debtor, and there are, of course, different causes that can lead one into the state of insolvency or bankruptcy, and those cannot be treated on the same way. So if we again back into the education courses, if we are treating to all debtors on the same way, we are missing the fact that there are different causes and how to treat those causes on a tailored way. So these specific circumstances are very important to what, again, can be imported from the idea and the philosophy of the problem-solving courts of a specific rehabilitation program that is linked into the specific case and can provide a quality, meaningful rehabilitation, and not just, going into a program that can maybe fit or suit someone, but it's not relevant to someone else. TJ also has a multidimensional perspective, and this is another idea that Professor Pellman and myself are seeing from the problem-solving course as a very important aspect that can be imported and used in bankruptcy law. And if we are speaking about the interdisciplinary approach and interdisciplinary team, which is a very well known in the problem-solving courts, like the community court that we hear before from Tamar, we understand that there is a team, including social workers, psychologists, economics, and not only legal professionals. And the collaboration of this team can lead into a very quality program that can provide the solution to the individual, to the debtor that is facing the situation and find himself in some financial distress that led, in the end of the day, into bankruptcy. As I say before, rehabilitation is an ongoing process, and this is something that we know when it comes to the institution, to the idea of rehabilitation from the problem-solving courts, and this is what TJ look on as an ongoing process in order to go into the journey of a rehabilitation process. It cannot be a one-shot course. It cannot be a very short intervention. It should be a process. And this is what important to think about and to understand in order to create a meaningful rehabilitation. And think again about debt discharge. If I'm providing someone a debt discharge, it's wonderful, it's important. By itself, it cannot create a meaningful rehabilitation because it's not taking the individual through the journey of rehabilitation in a way that he will change his behavior probably, and then he can find himself again in the cycle of death and maybe bankruptcy again. Another very important aspect that we are dealing with in our research is the role of attorneys. And attorneys can be rehabilitating lawyers, contributing substantially to the rehabilitation of the individual, but they can be also a debt busters. They look on themselves as how we can assist our client to reach the minimum payment and get a debt discharge, which is a very common. Another thing that is really linked into TJ is the fact that through the process of bankruptcy, there are different psychological aspects like shame, guilt, anxiety, that if a lawyer, an attorney, is well trained and understand the importance of TJ, it can help the client to go through this journey with a therapeutic outcomes rather than anti-therapeutic. Of course, judges, they are very important and they have a very important role in this process of financial rehabilitation. And we are also giving different examples and guidelines that we think in our research can contribute to a meaningful financial rehabilitation. Now, one of the important recommendations that we have in our article related to why not establishing a dedicated problem-solving court for bankruptcy law, which putting into the center financial rehabilitation with, of course, using and adapting the DNA of TJ and the understanding of TJ. And just to highlight in the short time that we have, it seems like a very practical recommendation since we are speaking about integrating into existing problem-solving court framework that already exists, alignment with therapeutic principles. We have supporting mechanisms like the multidisciplinary teams that we just spoke about. We have the collaborative knowledge platform. Therefore, if we want to handle in a very quality way bankruptcy cases and to aim to a meaningful financial rehabilitation, it can be done in a very good way in a dedicated problem-solving court. Now, just to highlight a few points regarding the reforms that we are suggesting. We do think that we need a clear statutory framework. The clarity on financial rehabilitation as a key objective should be very clear in the law. One of the problems that we identify is that there is no clear definition or framework or tools to the court how to handle those cases and what can be done, and that's the place where the gap can be expanded. And rehabilitation, as we said, and you understand, should be behind a mere debt discharge. Regarding the legal procedures, we do think that the interdisciplinary professional team can bring a substantial improvement to the process, and again, to focus on the debtor's circumstances rather a uniform program or generic information. The participation, by the way, of the debtor itself in the process is crucial in order to achieve a meaningful rehabilitation. Otherwise, there is no process. As we heard regarding the community courts, the rehabilitation process is built in a phase after phase by phase structure in order to being able to navigate into the process until reaching, hopefully, the final stage. And regarding judges and attorneys, there is a very important role, of course, that adapting the models of representation and therapeutic judging can create a substantial change into the process. One bullet point that is very important both to Professor Perlman and myself is the fact that we think that the time to start is law school. The best time to start is while we are providing, equipping the students who are the future attorneys, the future judges, and those legal actors with the right understanding of TJ and how to handle those cases. Education, just to touch, again, we need a tailored programs on an early stage, addressing the specific circumstances rather than any generic courses that important, but they are not creating the change for the individual itself. Just to summarize and to conclude, financial rehabilitation not realized yet despite legislative intent. TJ is a very important framework to bridge the gap that we touched before. And should we again use the DNA of TJ, importing the insights of TJ, the principle, the norms, the tools that already existed with the right mechanism, or as Professor Wexler well said, the metaphor to pour wine into the existing bottles, we can make a tremendous change and hopefully to achieve this financial rehabilitation. Thank you very much.